All right, court is calling 2019 CR 8713, State versus Jonathan David Vargas. Can I have parties announced for the record?
Remaining for the state of Texas.
John Foley, Your Honor, on behalf of Mr. Vargas.
And are you Mr. Vargas?
Yes, sir.
I'm no gum chewing.
I'm sorry.
There's a trash can over there.
Thank you. My apologies.
Problem. Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision? With your attorney, did you understand it?
Yes, ma'am.
Are you the same Jonathan David Vargas who was placed on deferred adjudication in 2019 CR 8713 for the offense of continuous violence against the family on September 12, 2019 for a period of 2 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. On or about the second day of March, 2023, in Bexar County, Texas, the defendant, Jonathan David Vargas, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State will waive the remaining violations, Your Honor.
Any objections to the waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is not, Your Honor. Both sides are going to put forth our recommendations.
All right, state, what are you recommending?
You are recommending that Your Honor revoke the defendant's probation, adjudicate him guilty, enter the affirmative finding of family violence, and sentence the defendant to 2 years TDC.
All right, and what are you recommending?
Your Honor, we would ask that the court terminate unsat the probation officer, I believe is recommending the same.
Mm.
Also, if I may, let me, I had shown this to one of the state's attorneys, but Judge, tendering a letter from River City Rehab Center that shows Mr. Vargas has been voluntarily in treatment for the last 2 years, and I would call Mr. Vargas.
All right, can you raise your right hand?
Classic courtroom pivot. When the law looks bad, the defense goes human. That rehab letter isn't evidence of innocence, it's evidence of effort. The defense is saying, yes, he slipped, but he's trying. Judges see these letters every day. The question isn't, is he in treatment? It's, is this real change or damage control?
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jonathan Vargas.
All right. You may proceed.
Thank you, Your Honor. Mr. Vargas, would you tell the court about your treatment at River City Rehab Center?
Yes, I've been attending River City Rehab for about 2 years due to the use of substances, and I've been successfully doing what I'm asked to do there. I talk to my counselor, take UAs, I do whatever is necessary to keep going forward and being a better person.
Do you mind if I ask a question?
Please, Judge.
So, are you doing sober support meetings?
No, I'm not.
All right. Because part of that is asking for forgiveness and getting your life in order. And one of the things about getting your life in order is this motion to revoke. So why haven't you followed through on your conditions with probation? Because this is not your first motion to revoke.
Yes, during probation, I had told my probation officer that I was using, and she recommended I would be revoked, and that's the reason I stopped reporting.
But now here's the thing, you've been here before on a previous motion to revoke.
Yes, correct.
So that means that you already knew that I am the last word on whether somebody is revoked or not.
I wasn't aware of that. I was just.
But you were aware because you've been before me on a previous motion to revoke with the same violation, so you were aware. So part of being truly on the path to sobriety is honesty, right?
Yes.
And
of course,
internalizing things.
of course.
So you've been here on a previous motion to revoke. So you knew that I'm the last word on whether somebody's revoked or not. If I wasn't the last word on whether somebody was revoked or not, then y'all wouldn't be before me on a motion to revoke. You just go off and do your own thing. So if you're drug tested today, what are you going to be positive for?
Just my medication, methadone.
Right. So you're going to go do a drug test today, and then you're going to come back here and I'm going to make a decision.
Thank you, Art.
Right. And you have your ID with you?
Yes.
All right. So they're going to tell you where you need to go, and you're going to need to go to that specific place, not a different place.
Okay.
And they're going to let me know what that UA says today. So I'll have you all come back this afternoon.
Thank you, Judge.
All right. Thank you.
So even with pretrial as well?
Everything just paused, and now the entire case hinges on a cup. That drug test isn't procedural, it's decisive. If it comes back dirty, the court's patience evaporates. Judges don't like guessing, they like proof, and in this moment, science becomes the tiebreaker. This is the longest walk of his day, because when he comes back, the judge already knows what she's going to do.
No,
Oh,
they're going to tell you where you need to go. So
Okay.
just talk to probation.
okay.
All right. Thank you.
Thank you.
You're
So
welcome.
he does not need to report to pretrial, so.
No, I mean, if he'll talk with Ms. Abrams, he'll let him know what he needs to
They
do.
send me an alert to my phone. Do I have to go up to court?
You're here. If there's an alert, you know who would end up signing a warrant? Me.
You, okay.
All right.
Oh,
So you'll talk to them.
Thank you, Judge.
Thank you.
Just so the court's aware, I have, I told you I'm having surgery tomorrow. I've got a pre-op this afternoon.
All right. So if you can make sure that he signs the trial court certification, just in case. And then if you want to appear by Zoom, you can.
Oh, great. Thank you, Judge.
All right.
I can probably make it in, but it depends on how long it takes.
Okay.
To do it, because my appointment is at 4:45. It's out in Stone.
Okay. All right.
Thank you.
Thank you. You're welcome. Robert Keonis.
He's in custody, Judge.
All right. So you are requesting jury trial.
Yes,
The jury trial for him is going to have to be in the new year.
I was gonna announce not ready, Judge. Previously we come to court, the state didn't have the witnesses, but apparently they turned up. So I want to make sure I go through all the evidence with my client and we'll be ready to go whenever we come back.
All right. And how long do y'all expect this trial to last?
3 days.
5.
So with Robert Mauer, it's probably more like 2, but I'll give you
With all of
three.
his trials.
All right, Ms. Ferguson, I need a jury trial date, 3 days.
January 12th.
That should work, Judge.
All right, and counsel, again, he'll be brought over in this attire. If you want something else, you'll need to inform them exactly
ma'am.
72 hours.
We'll
in
get it
advance.
set up. His mom's here. I'll talk to her.
All right, thank you.
Judge, if I could, well, this would take priority. I've got a case in the 226. That's about 3 years old, but it's a bond case.
Okay.
I'll let you talk to Judge Robertson about it.
Oh, yeah, it'll be fine.
All right. Thank you, Judge.
Thank you. Kenneth Thompson?
Disabled may stay there, Judge?
Yes. Oh, he can remain there.
Oh.
Yes. All right, so have you all reached an agreement or no?
Cannot reach an agreement. We asked for a speedy trial.
All right, Mr. Thompson, we're gonna set you for jury trial. All right, it's gonna have to be in the new year though, because the last jurors that are going to be available is December 11th. And we're going to be in an attempted capital murder case here. So your case is gonna have to be set in the new year, all right? In the new year, 2026. It'll be, we'll see if we can get you in January, okay? All right, Ms. Ferguson. All right, so we're gonna bring you back on January 12th.
2 days, good.
All right, thank you. Ms. Ferguson, they say 2 days. All right, David Hernandez. And counsel, are there any applications?
No, Your Honor.
All right, David Hernandez, if you'll come up.
He has a hurt foot, so it might take him.
Oh, he does? Mr. Hernandez, you can remain there. They tell me you have a hurt foot, so you can remain there.
Do you want to walk up here? or wanna sit in? It's okay.
You sure? Okay. All right, court is calling 2025 CR 013106, 2025 CR 013964, State versus David Hernandez. Can I have parties announced?
Megan Galley for the state.
Megan Enriquez for David Hernandez.
And are you Mr. Hernandez?
Yes, ma'am.
Counsel, have you received all discovery and
Yes.
reviewed that with your client?
We have, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Hernandez, in each cause number, did you review what's entitled true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, in cause number ending in 06, are you proceeding on the indictment as presented?
No, Your Honor, we are ready to proceed on the lesser included offense of possession of controlled substance, PG1 less than 1 gram, and evading the punishment in those.
No objection. That's our understanding.
And then in cause number ending in 64, are you proceeding on the indictment as presented?
They're reading.
Any objections?
No objection, Judge.
In each of those cause numbers, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
In each cause number, the state is proceeding on an offense that's a state jail felony, possession of a controlled substance, penalty group 1 less than 1 gram. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have plea bargaining agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered into a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
It's not my thing.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and was.
Mr. Hernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No,
Are you satisfied with the way you've been represented?
I am.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, I did.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
In each cause number, according to the plea, punishment is to be assessed under 1244 at 6 months in the Bexar County Jail. There's an $800 fine, no applications, and the causes are to run concurrently. Did you understand that to be the plea?
Did, Your Honor.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then in cause number 2025 CR 013964, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 013106, to the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. How do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State in each cause number, do you have any evidence to support the defendant's pleas?
Yes. State offers state's exhibit number 1 in each cause.
No objection.
State, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, I did.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In each cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing today?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that he's prepared to put these things behind him. He's suffering from a number of medical conditions and he wants to, move with where his mom lives and be with her and hopefully get adequate medical treatment for various things that he's struggling with right now. We respectfully ask the court to follow the plea bargain.
All right, and cause number 2025 CR 013964. The court will follow your agreement. Court will find you guilty, sentence you to 6 months in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. And this will run concurrent with 2025 CR 013106. And cause number 2025 CR 13106. Court will follow your agreement, find you guilty, sentence you to 6 months in the Bexar County Jail under 1244. There's an $800 fine. Time and money will run concurrently. Give you credit for any time served. This will run concurrently with 2025 CR 013964. Is there anything else with regards to sentencing in either cause number?
Just to make sure that he has credit for time served and that the judgments are satisfied in each case.
All right, are the judgments satisfied?
Yes, I believe so.
All right. In each cause number, the court will show that the judgment is satisfied.
Nothing further from the defense. Thank you, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, I do, ma'am.
All right, we can go off the record. Here's the thing. Using drugs and having your mental health issues is a deadly combination, right? Even when your body is in the best of shape, using drugs is a deadly way to proceed, because the one or two things are going to end up happening to you if you don't get help and maintain your sobriety. Either you're going to end up spending the rest of your life in jail or in prison, or either somebody's going to have to identify your body, because the last time you use may be the last time you use. You understand? When you're released from custody, if you need help finding a transitional sober support housing.
This wasn't sentencing. This was a warning shot. Judges don't talk about identifying bodies unless they mean it. This is reality, not rhetoric. What you just heard is the court saying, I can punish you, but I'd rather not bury you. And that's the part people miss about courtrooms like this. Sometimes the harshest words are the last lifeline.
Just come back here. I'll pick up the phone and call somebody to help you. All right.
Thank you, Your Honor.
All right. Good luck to you.
Thank you, Judge.
All right. So Elena Sanchez.